On the 6th of June, 2018, you drew the attention of the House to comments allegedly made by the Honorable Member for Asin South, in which you complained that those comments, if true, Asin Central, forgive me, if true, were contemptuous in that it brought the Honorable House into disrepute. After a little discussion on the matter, the Speaker directed that this committee investigates the matter to determine whether indeed the facts you put out, the words you said were uttered by the Honorable Member were indeed uttered by him, and if so, whether they constituted contempt. Now, you're here today, the floor has been given to you. Tell us why you think that the Honorable Member, or you allege the Honorable Member said what he said, and why it is in contempt.
Thank you very much, Mr. Chairman. Mr. Chairman, we have a preliminary legal objection.
Honorable Chief, please hold on. Yes, can I hear you?
It is so. Mr. Chairman, before we address you on the legal objections we have, may we, with your leave, pray that the description given to Honorable Kennedy Agyapong be amended and limited to respondent, in the sense that, in your own words, Mr. Chairman, at the moment, the complainant petitioner has him as a respondent. He has not yet been convicted. In our view, with the greatest respect, describing him as respondent contempt now would mean that the matter has been so determined and he is so guilty of contempt. So we would pray that he be described as a respondent in these proceedings, if your pleasure so grants.
Granted.
I'm grateful.
I'll describe him as respondent.
I'm grateful.
If you have any other,
yes,
please say them before we proceed.
Well. Mr. Chair, I proceed with my first ground of objection. And on this ground, I argue that the hearing of this matter creates a likelihood of bias. And I am fortified by graphic publication of Wednesday, June 27, 2018, front page story. Kennedy Agyapong has a case to answer. Privileges Committee. Mr. Speaker, if you come to page 16, the report has it. And with your leave, I refer to the relevant comments made by some members of this committee. One, in respect of the complainant himself, this is what is said or is attributed to him. Muntaka, speaking with journalists, Alhaji Muntaka said he has substantiated all that he had said about the contemptuous remarks by Mr. Agyapong with video recordings and documents. Quote, they looked at the evidence. Fortunately, because we have a video, we played, and everybody heard what is in it. I have done my part. They have asked me questions. I have answered all the questions. It is for the committee to determine what I have put before them. Alhaji Muntaka said he made reference to the Constitution and the standing orders of Parliament, and indicated that some members of the committee also quoted certain sections of the Code of Conduct for MPs. Mr. Chair, further, the Vice Chair of your respected committee is quoted as thus: the Vice Chairman of the Privileges Committee, Mr. Andrew Kofi Ejapa, told journalists that it had not extended any invitation to Mr. Agyapong. Further, Mr. Speaker, a friend of the committee is also quoted with respect as having said that a prima facie case has been established against the Honorable Kennedy Agyapong. And I read, after a meeting, a member of the committee, Mr. Samsnahi, told journalists that the committee had determined that there was merit in the complaint. Mr. Speaker, when you bring a matter before a committee for determination, you do not go outside the committee's remit to now broadcast to the world that you have found evidence prima facie to indict the respondent. Mr. Speaker, as we speak, there is no report properly laid before the House for the plenary to determine whether or not a prima facie case has been determined. Therefore, we contend that these members, including the complainant, having granted interview to the press, have injured the reputation of the Honorable Kennedy Agyapong, and they have further prejudiced the outcome of the hearing which is before you today. We accordingly submit that considering all these, the said members, since they have not had reason to question the publication by Graphic, they should recuse themselves from the proceedings, else the likelihood of bias becomes of grave concern to us, because they have already predetermined what they think is meritorious, and that they have already gotten the media to think in one way or the other against the respondent. That is our first ground.
If you have a second ground, please proceed.
Mr. Speaker, interlocked with the first ground is the likelihood of unfairness in the aforementioned statement made by the honorable members who are members of this committee who granted interview to Graphic. Mr. Speaker, I move to the next substantive matter. Mr. Speaker, this matter came before the House on the 6th of June 2018 and is captured in the official report of the House, which has since been adopted. Mr. Speaker, the complainant anchored his application on Order 78 of the Rules of the House. He again relied on Order 91B of the Standing Orders of the House. And I quote, at column 1071, he says, Mr. Speaker, I am coming under Standing Orders 91B to draw the attention of the House. Mr. Speaker, with your permission, it reads, debate may be interrupted by a matter of privilege suddenly arising. Emphasis mine, suddenly arising. Mr. Speaker, if you come to column 1073, he again says, I would want to come understanding Order 78A, which says, unless any order otherwise provides, notice shall be given of any motion which it is proposed to be made, I quote him verbatim, except the following, a motion relating to contempt of Parliament. And he goes further to say, Mr. Speaker, I come under this to move that our honorable colleague, Honorable Ken Agyapong, be referred to the Privileges Committee on the basis of his conduct and utterances against this House, the majority leader, and against many well-meaning Ghanaians. Mr. Speaker, procedure in a quasi-criminal matter, the nature of it is before this House. requires that not only are we supposed to emphasize substance, but the required processes to initiate an action is relevant and is very critical. Mr. Speaker, if you go through the proceedings thereafter, nowhere was this motion ever carried. Nowhere was this motion ever carried. It is our rule that when a motion is moved, same must be carried. This motion was moved. We had contributions. It was not even seconded. And it is a matter of record, Mr. Speaker. Honorable Alhaji Inusa A.B. Fuseni, when it got to his turn to speak after the motion had been moved, said, Mr. Speaker, it is with deep reluctance that I rise to support this motion. You support the motion after it's been seconded. So, Mr. Speaker, we invite you to hold that again, this motion, which has invoked the jurisdiction of this committee as a result of a referral by the plenary, was defective, and you cannot place something on nothing. Est in Winhilis, et in Hilus. The superstructure would fall, and same must not be countenanced. Mr. Speaker, I go to the third ground. Mr. Speaker, on ground 3, Mr. Chairman, ground 3, it is our case that the evidence upon which this petition is mounted is not coming from proper custody. Mr. Chairman.
Honorable, has any evidence been put before you?
Mr. Chairman, I will demonstrate the same in due course.
Well, I think if you have objection to evidence, you wait. So the time that the objection is tendered. Now, I thought you said you were moving preliminary objections.
Mr. Chairman, I take a cue. Mr. Chairman, it is our case that the evidence upon which this complaint is mounted has not been made available to the respondent. Mr. Chairman, we have heard that you have heard the complainant in camera and you have determined a prima facie. The rule of natural justice demands that a respondent must be given ample opportunity to prepare his defense. If the evidence upon which the complainant relies is already before the committee has given us notice of these proceedings because there is prima facie, we are of the view that the committee haven't failed to make available the said evidence to us to study and determine whether or not this evidence is indeed something that we have said would amount to unfairness against us. Our right to fair hearing is somewhat curtailed, and we are of the view that until we are given the opportunity to access the said evidence and study, this matter cannot be heard by way of the complainant leading evidence for cross-examination. Lastly, Mr. Speaker, Mr. Chairman, lastly, we have just taken custody of a communication, and with your leave, we would like to read same in full and aloud. The Chairman, Privileges Committee, Office of Parliament. We, the undersigned members of Parliament, hereby, fortified by Order 1644 of the Rules of Parliament, disqualify ourselves from the ongoing investigations involving Honorable Kennedy Agyapong. As you may be well aware, the respondent is the caucus chairman for the Central Region, and all of us have a close relationship with him. We are unable, therefore, to discharge our duties without bias. Please accept our decision to recuse ourselves. Most grateful to you, sir. Signed, Honorable Cynthia Morrison, MP for Agona West, Honorable Nana Iya, MP for Gumwa Central, Honorable Samuel Nsuwajan, MP for Upper Denshire West. Mr. Speaker, these have all been signed. And Mr. Chairman, we took pains to look at the said provisions. And Order 1644 reads, a member of the committee may disqualify himself from participating in any investigation of the conduct of a member, officer, or employee of the House upon a declaration in writing that he cannot render an impartial and unbiased decision in the case in which he seeks to disqualify himself. If the committee approves and accepts such disqualification, the chairman shall so notify the speaker, who shall request the leader of the same political party as the disqualifying member to designate a member from his party to act as a member of the committee in any proceeding relating to such investigation. Mr. Speaker, we think we have to bring this to your attention because we were copied and we are in possession to argue that in the circumstances that members have intend to recuse themselves, and is their right to do so, it would be proper for the purpose of due process to follow in full the procedure required for their replacement so that the hearing may proceed. Mr. Speaker, Mr. Chairman, we humbly so submit and count on a favorable consideration of the issues we have put before you. We are grateful for your patience and your kind audience, Mr. Chair.